Hi, everybody. I'm Vasantika Srinath. I'm a lawyer by profession. I'm currently in-house. I'm an in-house counsel working for Concentrix uh, based out of Bangalore. My role here is I'm leading global corporate compliances, which include contract and regulatory compliances. I also was responsible for GDPR compliances some time back. Now I am focused more on privacy for India and the ASEAN region, apart from a global compliance role. So that's about me. Um, so we are actually in the midst of implementing our Thai privacy law compliance. So which is why I thought it's a good opportunity for me to pick that as a subject to talk about. So I will share some of the knowledge that we have gained in the as part of this project, and can share it with everybody. So here goes my presentation. So before I start describing the uh, law by itself, I wanted to just give a very brief background of Thailand as a country. So unlike India, which is, we are so used to this kind of a multi-party democracy, Thailand is a constitutional monarchy. They have a king, and they call it a parliamentary democracy. So they also have a lower house, upper house, and elections and all of that. The current king is His Majesty King Vajiralongkorn, and Prayut Chan-o-cha is their prime minister. So they did not have a codified constitution until 1936. After that, till date, they have had almost 20 versions of constitutions or charters. So there is a new government, and new thoughts, and they start changing the constitution. So that's how it has been. So it's you know amazing. From 32 till date, they've seen 20 versions, and also it is a very strong military. So they've had 13 successful coups and 9 unsuccessful coups. Just over not even 100 years, they've seen so many, and the most recent one was in 2014, after which the current prime minister came to power. Despite such a you know turmoil turmoil-filled political scenario, and also their regulation seems so tumultuous with so many constitutions. They seem to rank very high on the ease of doing business, fifth in East Asia. Between India and Thailand, there is a trade and business of over $9-10 billion, mostly in food, electronics. It's more, import export and that kind of a business. But there is so somehow there, you know, this political outlook does not impact or hurt their business. The business world continues, and those laws do not seem to really be shaken up or changed in the manner that their constitution has been written and rewritten. So we can expect, some amount of stability, despite so much of lack of apparent stability. We can still expect some amount of stability when we look at privacy law. Is what we feel. I'll move on. Their legal structure. So it's a country with 4 principal fundamental codes. They have a civil code, commercial code, civil procedure code, criminal procedure code, and they have the penal code. So their constitution is supreme. It's followed by legislations, pretty much like we do in India. But out there, judicial precedents are non-binding. So that is a very big, difference from what we see in India. For us, judicial precedents have a lot of. We have the concept of ratio decidendi, and so if there is a order of the same court or a higher court, it is binding, while in Thailand, it's non-binding. It only has a persuasive effect. So looking up precedents may not necessarily help us. The judiciary is supposedly independent from the executive. However, the judges are appointed by the king. So this is, to give you a background of the economic, socio-economic structure and, of Thailand. With this, I will move on to the Personal Data Protection Act. So it was passed last year in May 2019. It was given the royal assent by the king on 27th May, and it was supposed to take effect on 27th May 2020. However, this year in May, they again, the cabinet approved a royal decree which gave a 1-year partial extension for the enforcement of the act. I guess it's COVID plus, complexities in having to be able to comply with this when there is so much other, confusion and a lot of instability that we around in the current time. So general requirements and obligations on data controllers, such as consent, providing ability to be able to withdraw consent, establishment of lawful basis for processing data, then various requirements that they put on collection of data and processing minors' data, which requires either parental or consent. So some of these things have all been we've got 1 extra year to be compliant with that. It also includes appointment of data protection officer, and also for any litigation, filing complaints, penalties. So no penalties will be levied during this 1-year moratorium period. So there is also a transitionary provision in the Act on how you can continue to process data which has already been, being processed prior to the Act. That also, continues to a person who are connecting data and processing it before this act was passed, will continue to do so for the next 1 year, and then they will have to start ensuring that they have the necessary consents and mechanisms in place to process that data. But having said that, the data controllers are still expected that they have to have some minimum level security measures to ensure that the data that they process is safe and safeguarded. The Ministry of Digital Economy and Society is yet to notify these requirements, but it's expected very soon. So that is awaited. Sorry. The key terms. So some of the, they don't have, the act is pretty small with very few definitions. So they have very few definitions, which is one is personal data, any data pertaining to a person that enables identification also. So basically it includes personal information and personally identifiable information. Both PI and PII has been included into the definition in just one sentence. Person is a natural person. It does not include a deceased person. That is clearly brought out in the definition of personal data itself. And then they have defined a data controller and a data processor. So there is no specific definition for a special category of data, like we have sensitive data and things like that. But there is a section 26, I'm sorry, which is the equivalent Article 9 of GDPR, which talks about explicit consent to collect personal data for that will affect the data subject. So over there, there is there are some descriptions which could be construed as the definition of special category of personal data, which includes racial or ethnic origin, opinions, cult, and some of these which I have mentioned over here. So these are for the key terms in the Act. if anybody has, anything to say, you might, just unmute yourself, and you can stop me on the way, and we can, discuss.
Vasantika, Bimesh here. How are you?
Yeah, I'm good. Thank you. Tell me.
Yeah, so maybe and later on, they're saying, racially, like, they have only one race there in that country, right? Why did they specifically put that word racially, like
So they have one race, but it's also they have Chinese, they have their local ethnicities, and they have to us they all seem like one race, but they do have multiple races. If you go there, there are so many Indians, there are so many people who have settled from so long.
Oh, okay. Just wanted to be sure. Thank you.
Yeah. So so then with this, I'll move on to controllers. So the controllers are supposed to, controller is the person who's actually collecting the data and processing it. I am making the assumption in the group that people have a basic knowledge of privacy laws. Either you're familiar with the Indian or GDPR, or one of these laws. So I will skip some basic definitions, which if someone needs me to stop, you please feel free to ask me to stop, but otherwise I will assume minimum level of knowledge. So the controllers are responsible to ensure that the data is accurate, up to date, complete, and not misleading. Which means there is though they have not prescribed how, but the controllers are required to create their own mechanism to ensure that they keep the data that they have, and ensure that it is verified. And so that's a very onerous obligation, but that is imposed on the controllers. They have to ensure that data is collected only from the data subject directly. So otherwise, you can collect data with information to the data subject, but within 30 days after that, you have to go back and obtain subsequent consent. Except, or else there are some cases where consent is not required, which we will see the exclusions to consent, which is similar to most other laws for emergency or health reasons and things like that. But otherwise, largely you need to go back and obtain subsequent consent, and which means you need to have a very robust mechanism for them to be able to withdraw the consent also. Then data controllers have to provide appropriate technical and security measures. So they are yet to notify the standards, but there will be the PDPC refers to the Personal Data Protection Committee, which is appointed by the under the law. And the controller is also supposed to review and keep checking whether the appropriate technology and technical and security measures are sufficient. If there is any data breach, notification period is 72 hours. So it's similar to others. You have to ensure that the consent notice is easy to understand, it is not deceptive, misleading, and that consent is truly and freely given. So which is again very similar to what many other regulations talk about. And for them, the age for minor is 10. So anyone below 10 or otherwise not having capacity to consent, the controller needs to ensure they have sought consent from either the parent or the custodian for such persons. But there is no specific provision which says you have to provide for extra measures for safety of such data or things like that. It's only the only reference comes where it comes to consent. They also have the data controller has the primary responsibility to ensure that processing is compliant with the PDPA requirements. So the basically processor has to blindly follow instructions of the controller. Then where personal data is to be provided to other persons, then controller has to ensure that such data is not used unlawfully or without authorization. So, they have to take that extra step and be very cautious in how it is shared with third parties. They also have to put in a system for examination system for erasure, destruction of personal data. So, also we should be able to destroy data, or we should be able to to ensure that retention period, if there is a limitation period has expired, or there is a specific requirement of retaining data for a period of X years. After that, you have to ensure that all the personal data is duly destroyed or erased, or if the subject has withdrawn consent. So that system needs to be put in place in a proper manner. So then I apologize. My slides have seemed to move a little, up and down. The exclusions to consent is over here is gone up. So I'll just be, shuffling a bit. Yeah. So these are the data subject rights. The right to be informed, right to access data, right for data portability, to object to the right to object to the way the data is being processed, which is basically also the right to withdraw consent, and right to erasure or to be forgotten, the right to restrict processing, and right to ensure that the data is rectified, corrected, and updated. It is also, that is the obligation of the controller, and it is a right of the data subject. And just like in the GDPR or even the Indian draft bill, none of these rights are absolute rights. These are subject to other regulatory requirements. So if a person says, I want to withdraw my consent, but under law we are entitled to retain it, or we are required to retain the data, then that will obviously apply over the withdrawal, and withdrawal will kick in only after that period has expired. So that is about the data subject rights. The exclusion. So these are the clauses. I'm sorry, these are the activities which are excluded under the purview of the Personal Data Protection Act entirely. These are the exclusions to the law. This is collection by individuals. So if an individual is carrying on any business for personal benefit or for a household activity, then that is exempted. Public authorities are exempted. Then mass media, so journalism, literature, fine arts is also exempt under this law. Any proceedings under before the House of Representatives, Senate, or Parliament is exempt. Courts and officers in legal proceedings, and a credit bureau company and its operations. So this is a very strange insertion. Possibly, I am yet to verify this, but there might be a separate law in Thailand that governs how credit bureaus will gather and store data regarding people's creditworthiness and how it will destroy it. So, maybe that is why it is excluded, because otherwise this is a business that, is filled with people's personal information and their history. But that is also excluded from the purview of this act. Yeah, so then I apologize, there was a slight up and down on this. Yeah, so then after the data subject rights, I'll move on to, these are under which, these are the clauses under which you can processor or controller can process data without consent. So it could be for preparation of historical documents, or for archives for public interest, to prevent danger where there is danger for a person's life. So you have to save a person. You don't need their consent to give them medical treatment. or else where there is a performance of a contract. So if there is already a contract and you don't need extra consent, then you don't need to come under the PDPA for added consent. Or where there is a task carried out in public interest, or they also have the concept of the legitimate interest of a controller. So that is also a way to be able to exclude consent, or also for compliance with a law to which the controller is subjected. So it's only the controller, not the processor. But if the controller is subject to a law that needs him to retain or process data in a particular way, they are not required to obtain consent of uh, data subject for that. Cross-border transfers. So cross-border transfers are permitted only to countries that have adequate level of protection as prescribed by the PDPC. They are yet to notify what they mean by adequate level of protection. It is cross-border transfer is permitted with consent of data subject, or where it is necessary to perform obligations under a contract in public interest, or again where it is required for to suppress or prevent danger to life or something. But in addition, for group companies, we typically went with either they were under the GDPR, we had binding corporate rules, or the data protection agreement between group companies. So this regulation does not talk of any such thing. So we are yet to see what the committee will come out with, but they will hopefully come out with something that will approve a standard contract between group companies, so that we can transfer data within between countries. But they also have a very different requirement, which says that where group companies or affiliates are transferring data within the group outside of Thailand, if they have a personal data protection policy, that policy should be reviewed and certified by the Office of the Personal Data Protection Committee. And once that is certified, then under that certification, a company will be able to transfer data within the group. But what are going to be the requirements in order to get that approved and certified is yet to be announced and notified. Then these are about the processors. Processors are the ones who will carry out the activities. They're supposed to act only under strict instructions of the data controller. There is a slight, there is a exclusion saying except where instruction is contrary to the law. So now it is putting an obligation on the processor to check whether instructions given by the controller is as per law or not. So there is, which puts a little difficult situation for a processor, and it also says that if the processor does not act under instructions of the controller, the processor can be deemed to be a controller and also could be subject to penalties. So this is a slight dubious situation that is being the processor is being placed in. It's little tough, but that's how it goes. The processor is supposed to provide for appropriate security measures to prevent unauthorized or unlawful loss use to the data. So this again should be based on instructions and agreement with the controller. And if there is any breach, it's supposed to notify the data controller at the earliest. A processor is also required to prepare and maintain records of all the activities that it is undertaking where it's processing personal data. So they have nowhere talked about what kind of records are to be maintained anywhere. So but that's it's this hopefully there will be more details when the committee comes out with more notifications and announcements on these things. Then there is the appointment of a DPO. So DPO is required where there is, if it's a public authority, or if there is a substantial, huge amount of data being, personal data being processed or being monitored, uh, that is such, businesses will require a DPO, or else where the core activity is collection, use, or disclosure of sensitive personal data, they will also require. So the DPO, like in under all other regulations, is the one who's supposed to advise the data controller or processor, whoever it's appointed for, including the employees or service providers of the controller with respect to compliance with this act. So one way of looking at it is that the DPO is employed by a company and will advise the company and its employees to ensure that the controller or processor is compliant with the act. But the way it has said, including the employees, hopefully it is not putting the DPO in a conflicting situation where an employee who has a doubt whether his data is being processed correctly can come and ask the DPO, and the DPO has to, give advice to that person while he's actually engaged by the company. So I hope that's not the intent, but it should ideally be advice to employees who are working on that particular processing of data to ensure that it's being compliant. DPO is also supposed to coordinate and cooperate with the data protection, the personal data protection office, if there are any issues in collection, use, or disclosure, and also ensure that it's able to monitor and verify compliance with the PDPA of the company, and conduct regular compliance audits and inspections. So, like under other laws also, the DPO is protected under for cannot be dismissed or terminated because he or she has performed his or her duties under the act, and the DPO must be able to directly report to the CEO. So similar to the GDPR, have to be able to report to the highest level of management is the word over there. Here it directly says Chief Executive Officer. So they also say that the data protection officer can perform other duties and tasks, but then they will have to come back and explain to the government, the PDP office, that these tasks will not result in a conflict of interest situation for the DPO, so the DPO can successfully carry out both tasks. So then, so this pretty much sums up most of the provisions under the PDP Act. There are under the law provides for both civil and criminal penalty, so it can go up to 5 million baht, and there are if there is a data, subjects can even lodge class action lawsuits out there, and court can give punitive damages which could be up to twice the amount of the actual compensation amount that the person is claiming, after determining what is the severity of the damage cost. So there could be basically you could face um, civil suit under a contract for violation of the provisions of this. You could have a claim in torts against you. You could potentially also face criminal action. So there are various ways a person could um, you know uh, end up having to litigate on this. These claims are the time barring is 3 years from date that the injured person is aware of the damages and knows the identity of the controller or processor. So if I have who is liable, or 10 years from the date from when the wrongful act took place. So there is up to 10 years that a controller or a processor could potentially get sued. So this is my last slide. I've moved pretty fast. So this slide sets out some of the key differences from GDPR. I'm talking of GDPR because most of us, that's deemed as a gold standard, and plausibly the Thai Act came into effect because all countries are vying for adequacy ruling from Europe, and therefore most of the laws are also sort of mirroring the GDPR. So the PDPA does not specify online identifiers, unlike the GDPR. It specifically talks of online identifiers and how to deal with them. The PDPA does not have definitions, or does not even talk about anonymized or pseudonymized data, but it's left unsaid. But obviously, if you have pseudonymized or anonymized data, it is not and so long as it is not identifiable or does not identify a person, it will be outside the purview of the act. But the only catch is pseudonymized data can you can work backwards, and it could come under the scope of the PDPA. So there is a little catch over there by it being expressly not being talked about. They have also not referred to any requirements for data minimization, or to carry out, there is no obligation to carry out DPIAs, or to have a privacy by design, or even privacy by default, though these might be good practices to carry out, but the law does not ask anybody to follow any of these methods. Also, the PDPA does not have any additional safeguards where it comes to processing children's data, except where it talks of consent by a parent. So there is no extra safety or protection for that, which also could be a potential weak point. So so with this largely sums up the this largely sums up the key clauses and provisions of the Thai PDP Act. Um, any thoughts? We can discuss. Please feel free.
Did you say anything about the extraterritorial application of the law? Is there any?
Yes. I don't know if that slide got missed out. So it's applicability is where the data is being processed.
Okay.
I'll just I'm just sharing that screen again. Yeah, I think there were some slides which went up and down, and yeah, so it is where there is use, collection, use, disclosure by a controller who is in Thailand, regardless of whether the collection, use, disclosure takes place within Thailand or not. So one, if that company is in Thailand, and second, if the controller or processor is outside of Thailand, Act will apply to any data in respect of the data subjects who are in Thailand. So it does have extraterritorial and applicability, just like the GDPR. But the first point only is a little gray, because it's if a person is in Thailand, the controller or processor, but the subjects are outside, and especially if it is a processor who is in Thailand, who is supporting somebody in some other country which may or may not have a law. And if that processor will become subject to this law, there will be a conflict of law.
Yeah.
So that is a little issue. So, but yes, they do have extraterritorial applicability.
India has similar provision with exception available for a notified company which is processing the data of foreigners. Okay.
Correct. They have not provided for that kind of an exception or notification.
Okay. Penalties?
The penalties will go up to 5 million baht, and it could go so for one is for breach, or one is for where it's processing sensitive data. For all of that, there are different set of penalties that are prescribed. And if a processor does not follow instructions of the controller, then he can be deemed as a controller and can be liable to the penalties that would have otherwise, been on the controller.
Yeah, that we can understand because
Yes.
that is also there in other laws. On
Correct.
notification, data breach notification.
So now the notification was on 27th May 2020.
No, data breach notification.
Sorry?
Notification of data breach.
So the date within 72 hours you have to notify.
Okay, to the controller.
Correct, to the controller. So again, they have not expressed to whom you're supposed to report and how to report. So the processor is supposed to notify the controller. Controller is supposed to notify within 72 hours. But under which circumstances to inform the data subject or only to the PDP office, how that is to be dealt with is still not talked about. Maybe the one notifications or some ruling will come by the PDP office to explain these points also.
Anyway, since there is time up to 2021, I think there is some.
Correct. And they have also constituted the office, so the office can come out with their notifications and regulations under the act. So once that will start, then there will be more information available.
Vasantika,
Yeah.
in case that some new technology is being used now, because DPIA is not spoken about, is there any mechanism where you have to check if it's a high risk technology that you will implement, or there is just nothing and all the general provisions keep applying?
Only general provisions keep applying. They have not talked about the need for DPIA, but they have there are data subject rights and exclusions for consent. So there is the legitimate interest and performance of contract. These are options under which you will be able to use that technology. But I would say it will be a matter of good practice for us to do a DPIA and document it. So tomorrow, if you say that you have gone under legitimate interest, or you have chosen to do that for performance of a contract, you should be able to explain your standing, right? So the best way will be to still perform a data privacy impact assessment.
Okay.
Thanks.
Yeah.
Thank you.
Any questions from others?
Yeah, I heard someone saying something.
I'm Adepu from Bombay.
See, Vasantika, Dinesh here again.
Yeah. Dinesh, Adepu was just saying something. Can he finish?
Yeah, I just started. Yeah. So actually, one thing to me is like the minor's age is 10. I mean, you are a law person. Is there any specific reason that, if you look at India and US, I mean, Western countries, it's 1 or 2 years of difference. It's like a huge difference, I see. That is one question.
I don't know, frankly, the detailed law in Thailand. So I looked at this, I saw 10 years, so I made note of it and I have pointed it out. Okay. It also struck me. But in under GDPR, in some European countries, I have even seen 13 years, 14 years. So it differs from country to country.
Okay. But do they have any like subcontractual, standard contractual clauses like European countries? I mean,
no,
GDPR has like.
Yeah. So the standard contractual clauses, or they have not prescribed anything still. But hopefully the PDP committee will start prescribing these documents.
But how do you guys like transfer the data? How do you handle the data movement from Thailand to India when it comes to your company? I mean, you don't have to be specific.
Yeah, so I will, we did talk about the cross-border data transfer. So as of now, they are saying that for group companies, you're supposed to have a personal data protection policy. and that policy has to be reviewed and certified by the office of the PDP committee. So once that is done, then you will be able to transfer data. But we still have time till May 2021 to do that. But we will have to get the policy certified, basically, for intercompany transfer.
And yes, there was a nice comparison you did was like, the PDPA of Thailand and GDPR. And
Yeah.
PPD is the heart and soul of that, GDPR, I feel. That's where I think, GDPR has a strong DNA. And I think it weakens this, like act, I feel. I mean, what is your take on that?
Sorry?
I mean, when you look at GDPR and PDPA,
correct,
privacy by design is missing in PDPA. And
yeah.
PDPA makes the GDPR, it has strong DNA because of that. It's heart and soul of that, GDPR, I feel.
Yeah. So, that is why I specifically pointed out that, privacy by design is missing. Even privacy by default is missing. They have not asked for data minimization. So it is actually a very soulless law. They have enacted it because it needs to be done. You will get adequacy ruling. But it's not done because they genuinely believe in it. At least that's the feeling you would get, especially, when you are familiar with something which is, which requires...
Maybe they're preparing preparing today for the previous one. I'm not sure, like, this doesn't make sense. It doesn't have that PDPA, I mean, privacy by design.
So I would still say, it's good practice, and good practices, best practices are always an option for us. So we would ideally still want to do a privacy by design, because that's your best way to be compliant. Instead of, that's your way to be compliant with a vision rather than having to do a postmortem all the time. So I would say, even if the law doesn't say that, these are, things that companies should openly embrace.
Yes, that's actually minimum requirement. Even customers are going to pay you extra if you, use that as a sales pitch also, like,
Correct.
Products. Yeah.
Absolutely.
Okay. Thanks, Vasantika.
Yeah, thank you, Ganesh. Yeah, Adepu, you were saying.
Vasantika,
yeah.
In Thailand,
you're very soft, Adepu. Can you speak a little louder?
Yeah. In India, we have the way law is delivered, judgment is delivered, it takes a longer time in our experience. What is the general condition of the law delivery, the judgment delivery in Thailand?
I don't know. I have fortunately not had to litigate in Thailand.
Okay, because you have a company there, that's why.
Yeah, but fortunately I have not had to litigate over there, so I don't know.
With this current content of this particular law in Thailand, do you think that it will become a adequacy country for the GDPR?
I don't know. They have, I guess the attempt was to ensure that they will get an adequacy ruling. But whether the EP will give it is, for the EP. Sir, you feel that this kind of a regulation without...
Vasantika's presentation, Adepu, do you give the adequacy to Thailand?
No, sir, I can't give, compared to our Indian law, which is upcoming our PDPA.
Yeah.
With the Thailand, I don't give the adequacy status to Thailand.
No, they will not get, even Indian law will not get. So there is no way Thailand law will get adequacy status.
I am comparing our upcoming PDPA with the Thailand PDPA. I don't consider this any strong basis there.
Correct.
It's a very what we call IVAS.
Yeah, it is a very soulless law, that is what Dinesh also pointed. So that's why I pulled out those key missing elements. Yeah. And those are so critical to, make a nice, proper law.
It's kind of it's not a robust, law, I feel.
Yeah, it is not. So I guess, we all were able to just determine that the adequacy ruling is going to be very doubtful.
It is good to know that there are countries where only for namesake they have the law.
Sir, if you see the Thailand political history, this is no way going to help any people in the country. The unstability of Thailand.
I started with that. I gave that background because it will also give us an idea of, how they are developed or evolved to this point.
Maybe it is as like a scarecrow, like, we have something in place.
Yeah, it's possible. You want to just show something for whatever reason, so they have got it. See, this current PM also assumed power after a coup of 2014. So it's not, though it is called a democracy, he came after a coup. So there is still, so much of, so if he thought it was necessary to have it, he would have created a group and somebody has done it. See, they did not call for opinion or, people to give their inputs. They don't have any of those concepts.
That's the way democracy works there.
Yeah.
Okay. Yeah. Deepa, you have got any questions?
So this is Reena. Overall, it looks so simple, or Vasantika has made so simple presentation.
I think you are right. Vasantika made it very easy. It looks like, it's like,
Yeah.
very easy subject. Yeah.
It's very honest feedback. I was trying to ping. So it looks one of the easiest PDPA which we have seen till this time.
Very simple. It is 35 pages. My team Shom sat and first made a first cut. Then I also read the entire law and ensured that the key elements have been pasted into this.
Okay, okay.
If you see this, you have pretty much seen that most of it. 90% you've seen.
No, it seamlessly looks very, very comfortable, Vasantika. Thanks a lot for taking us through this.
You're welcome.
Yeah.
They've spent so many clauses just discussing the constitution of the PDP committee, who will be there. Half of the law is full of all their bureaucracy rather than the key legal elements. So it's a very small law in that sense.
Okay.
Vasantika,
Yes.
how is the cybersecurity posture of certain big companies there?
So we have our global best practices, which we will practice there. Even our clients over there and people we interact with are global companies, and they have their global best practices, which are implemented there. We have enough quality infrastructure to be able to implement that. That's the way I will put it. I don't think legally people are asked to do something by regulatory requirements, but it's a very, I would say, very progressive mindset. They have ease of doing business. There are all the big companies have a presence over there, and the cybersecurity is quite, they have quite a robust mechanism, I would say.
Yeah, because the law PDPA doesn't call out specifically on expectations on the cybersecurity.
Yeah, it does not.
Yeah.
See, and they don't even have, if you look at Vietnam, for example, they have a separate cybersecurity law itself. In Thailand, they don't even have something like that. But despite that, they seem to be running okay. Possibly there might be yet another law, but nothing that impacts privacy or personal data protection.
But how big is the market there for data generation from there and processing from outside?
I have no idea. I don't think they will have too much of a market for processors per se for export of services. Because for them, again, language is the barrier, right?
Yeah.
So because of that, most of the businesses will have to be domestic oriented. So possibly there will not be too much of issues. There will be very minimal issues for processors who are having this conflict of law problems. Is my guess. But obviously for the company for economy to grow, they will want to also export services. So that will be gradually will be an issue, I guess.
Okay.
Is there any draft for non-personal data also in Thailand, or they've not even started anything?
No, there is